Mr. Feldman.
Thank you, Your Honor. Good morning. May it please the Court. My name is Gary Feldman. I have the pleasure this morning of representing the 357 Corp and Trans Lease Group in this appeal. There are three issues that I would like to address today during this argument that may be a little optimistic, but we'll see how it goes. First, it's our contention that in this disability discrimination or handicap discrimination case, the Superior Court had no subject matter jurisdiction to determine Mr. Everett's qualifications to operate a commercial motor vehicle, which was the central issue at the trial of this case. His qualifications, Mr. Everett's qualifications to operate a regulated vehicle was solely and exclusively...
Excuse me, could you tell me exactly what the DOT does in regard to this license? So
Yes, Your Honor.
That would help decide this
Okay.
quote jurisdiction.
There is a comprehensive statutory scheme. Congress has declared that it is the DOT's highest priority to maintain safety on the public highways.
I just want to know procedurally what it does. Does it examine the applicant? Does it give a license? I mean, what
the appeal procedure, there is a section within the regulations entitled Resolution of Conflicts of Medical Evaluation. So when
But I think in answer to the question, before you get there, a doctor can give a certificate.
Oh,
right?
yes.
That's
okay.
what I don't understand. Does the doctor give a certificate, or does DOT? So does somebody from DOT come along?
No, it's a doctor.
It's designated to a doctor.
It's designated to a doctor. There are multiple pages of regulations that govern the medical requirements that an examining physician must follow in evaluating a potential driver, and the doctor renders a determination whether that particular driver or applicant meets the medical qualifications, and then a DOT license issues that certifies that that driver has been examined and is found to be medically fit, consistent with the DOT regulations.
Okay, so I assume DOT somehow issues it based on a doctor's letter. Is that what you're saying?
Yes.
Okay.
Is
You
the
never
DOT
say
sort
it
of like
in
a
the
registry of motor vehicles? Is it like a second registry of motor vehicles? Do you have to have that license and you have to be able to produce it to a police officer on the highway that stops your truck?
Exactly, Your Honor. If you're operating a regulated vehicle, the driver must have on his person a license indicating that he has been certified to operate that motor vehicle. And with respect to the carrier, my clients, they are absolutely prohibited from allowing to operate on the roads any driver that doesn't meet the DOT
right,
qualifications.
but who gives this DOT license? You're saying the doctor doesn't give it. The doctor just examines.
The doctor examines and issues the doctor's report.
I understand. And then how does a driver get a license, a DOT license?
I'm not specifically
that would
sure
be
of that.
That's very important. It's to the jurisdictional issue, and it's never made clear in the brief, and you tell me you don't know that. Because if there's a DOT procedure you have to go through, then you might have to exhaust that procedure. But if there's not, different question.
But the exhaustion of procedure that we're addressing here.
Why, I understand you say it's a 12b1, but most exhaustions are waivable. And was anything raised below?
No, Your Honor. Unfortunately, we scoured the record in counsel below. This issue was not raised below. There was no question about that. However,
so then if it's not jurisdictional, if it's not subject matter jurisdiction, it's been waived, and you can't tell us whether it's really subject matter jurisdiction.
It's our contention on appeal, Your Honor, that under the U.S. Supreme Court case of Davis and under this Court's case in the Central Transport case, that where Congress has enacted and implemented a comprehensive regulatory scheme and has established a specific federal forum for resolution of a particular issue, that is a preemption jurisdiction issue where the issue goes to the forum, not the law to apply, that is non-waivable. And that
Mr. Feldman, may I ask you this question? Assume that a doctor is examined. Assume that a potential driver is examined by a doctor, and a doctor completes a medical certificate complying with all of the extensive regulations that DOT has promulgated, and a certificate issues from DOT, with or without a hearing, makes no difference for the purposes of this.
There is no hearing.
No, it just issues, correct? And then it is determined by somebody, the employer, that the driver has provided any one of the following: incomplete, inaccurate, or false information such that the doctor has issued a qualified certificate on the basis of faulty information. Okay? You with me? I haven't asked my question yet.
I am with you.
And that information comes into the hands of the employer. At that point, what are the employer's remedies?
The employer at that point, the remedy would be consistent with his obligations to terminate or suspend or take that driver off the road. And in fact, a number of the cases we cite in our brief, Your Honor, deal with almost that factual pattern almost identically, where a driver or an applicant for a driving position
so the employer takes the driver off the road.
Yes.
And the driver says either the information was not withheld on whatever basis, or it's not relevant, or, I mean, the driver is now challenging. What is the remedy available to the driver?
Okay, under the cases that have had that exact fact pattern, and admittedly they have arisen at the trial level, the courts say that once the employer knows or believes that there has been fraudulent or false information, the driver has to go through the DOT process. The courts say that the DOT, under that appeal process, is the sole and exclusive body to make a determination as to the driver's medical fitness to operate a regulated vehicle on the highway. So,
and I take it that there are regulations that provide notice and an opportunity to be heard.
Yes, and there's a two-step appeal process within the DOT, and then from there it goes exclusively to the Circuit Court of Appeals for the District of Columbia.
Mr.
Okay.
Feldman,
Yes.
This, first of all, you say in terms of preemption and why it's subject matter jurisdiction, and you cited Davis and Central Transport?
Yes, Your Honor.
Do you cite them in your briefs?
Yes, we do, Your Honor. Davis is the United States Supreme Court case. Central Transport is this court's decision, and they are both cited and argued in our briefs, Your Honor.
I mean, we have Harris. Harris you cite. Now, does Harris rely on Davis?
No, because Harris is not a waiver case. Harris is the principal case that addresses the issue where you've got a driver and...
But it's a subject matter jurisdiction case.
Yes, it was at the trial court. It was a 12B1 subject matter jurisdiction, but it doesn't address the preemption of the waiver issue, Your Honor.
Okay.
This is a discrimination claim.
It's a disability claim, yes.
And the Superior Court has subject matter jurisdiction of discrimination claims. There's no question about that. So when the driver files a 151B claim, then doesn't the employer have a defense that there's a prior adjudication by a tribunal with jurisdiction that bars recovery here? And wouldn't that be not jurisdictional but a defense that must be raised?
Okay, well...
And is waivable, if not
To get to the point where we're at, Your Honor, I will respond to that with a two-step analysis. Start with Harris and a number of cases that follow Harris. At the trial court level, where there's a dispute between the driver and the carrier over the driver's medical qualifications, the courts have, with the exception of one Wisconsin state court, the Slazinski case, which I will address, the courts have consistently, when the driver brings a regarded at or is perceived as disability discrimination case based on the medical qualification issue, with the exception of Slazinski, every single case has said, we, the courts, do not have jurisdiction to resolve this dispute between the driver and the carrier over his or her medical qualifications. The language is quite strong. The courts repeatedly say that issue is within the sole province of the Department of Transportation through that Section 47, through that appeal process within the DOT, and every single court...
But always raised before trial in Harris.
Yes, Your Honor. Just like Harris. So that's the first step. So I think it's our position that it's well established that courts should not be, juries should not be making determinations as to the medical qualifications of commercial motor vehicle drivers, because it's a matter of national policy and national safety.
Yeah, but is that only true when the question involved is whether or not this person should be allowed to drive on the highway? Where here that really isn't the question, is it?
Well, the question here was, did Mr. Everett have a valid DOT-issued license? Did he meet the medical qualifications required by the DOT regulations? So although that issue was not raised at the trial court level, we contend that under the doctrine of Davis, as adopted by this court in Central Transport, that when you look at the regulatory scheme of the Federal Highway Safety Motor Vehicle Regulations, the Congress or the Department of Transportation has established an exclusive federal forum to resolve that very issue. That was the principle that Mr. Everett refers to it as a collateral issue at the trial. It was the principal issue at trial was a dispute concerning his medical qualifications. And under the Davis case and under Central Transport, in which this court adopted the federal analysis, where the jurisdiction, where the federal issue goes to the designating a specific forum as opposed to just a choice of federal law, the court cannot hear the case. And according to Davis—
why don't we suspend the Massachusetts proceedings to allow that fact issue to be resolved in the federal courts? Why is it a matter of subject matter jurisdiction?
Because Davis, according to Davis, says that the judgment, even at this point, even the judgment rendered by the state court proceeding is subject to collateral attack at any level. And that's exactly where we are. We contend that under this regulatory scheme, this comprehensive scheme, and federal preemption, congressional federal preemption can be found either expressly or implicitly, impliedly. And Davis was in both.
Did the defendant here have the necessary paperwork to get inside a semi and drive a truck across interstate highways?
The plaintiff, Your Honor?
The
yes.
Plaintiff.
Well, after the plaintiff stopped working for our carrier, after his hospitalization, when after four doctors' reports, 2 different doctors, including an independent third-party doctor chosen and agreed to by the plaintiff's union and my clients, all concluded that Mr. Everett did not meet the DOT certification, the DOT medical requirements, and would not certify him. Mr. Everett apparently went off, and when he came back to us,
my question is actually simpler than that. Did he have, if he were in a truck driving across the country?
The answer to that was yes, when he was working for a trucking company other than this one.
Yes, and he did that based on—
And he did that by failing to disclose.
Admittedly lying.
But he didn't have it for you, and the only question before us is whether he had it for you. It seems to me it doesn't matter whether he had it for the other companies.
Well, what matters to us is that when his union initiated this grievance in 1999, which my clients eventually prevailed on at arbitration for the second time, it became apparent, and Mr. Everett admitted, and Mr. Drew, our president, testified, Mr. Everett admitted that, yes, I've been working for other trucking companies, but yes, I lied. I misrepresented my medical history when I told these other companies that I had no history of a psychiatric or emotional illness.
So if he doesn't have this license, he fails to make out a prima facie case.
Exactly, Your Honor.
He can't show he's qualified. He's not. Can't drive.
That's not.
But that's a different. That's
that
not.
Is a different issue.
That's a different issue.
Yeah.
That goes to the. I'm sorry. That goes to the regarded as issue, which is separately. But in the issue that we're addressing here at this time is the jurisdictional issue that there's an exclusive federal forum, and that question is not waivable.
Mr. Feldman,
yes.
As you I don't know whether you had an opportunity to review the amicus brief that was filed yesterday by the Mass Commission Against Discrimination, but one of the claims made in that brief is that with respect to the 1999 discrimination claim, that's this one, right? Under 151B, Section 5, the action must be dismissed for failure to exhaust administrative remedies. Is that a different way of saying what you're saying?
No, that's a completely different issue, Your Honor.
Okay.
So
okay.
That's the second. That's one of the 3 issues I wanted to address. So that's another issue is that we've raised on appeals Mr. Everett's failure to meet the requirements of 151B.
Is that waivable?
Excuse me, Your Honor?
Is that waivable?
I don't know that was raised. The waiver issue, Your Honor, was raised for the first time yesterday at 4:30 when we received the reply brief from the plaintiff. I have not had a chance to address that. I've asked for time to.
That was not also not raised among many other things.
That was raised in the motion for a judgment notwithstanding the verdict.
Yeah.
For the first time. That was raised for the first time in a JNOV motion at the close of the trial. And if I can explain that, what happened here, Your Honor, is that, as you know, there was a 1997 charge of discrimination filed.
Yeah.
The complaint in this case, the Superior Court complaint, really only refers to specific events that occurred in 1996 and 1997, which are identified in the complaint, which track the MCAD charge. It does go on to say, and continuing thereafter, they failed to rehire him. At and during the trial, the plaintiff for the first time stood up and stipulated, according to the trial transcript, that they were waiving all issues relating to all events before 1999. So really the first time that the issue of the failing to file the 1999 really became ripe or became apparent, unless you had some crystal ball, was during the trial, and it was immediately raised in the JNOV motion. It was only and the question of is it waivable was raised really for the first time yesterday, and it's our position that that should have been addressed in the plaintiff's principal brief in opposition, and it's having been raised now for the first time in their reply is really not properly before
So they've waived the waiver issue.
Exactly, Your Honor. But we will, if given the opportunity, because we're buried with some briefs yesterday afternoon, we'd like an opportunity to respond.
Mr. Feldman, you did raise Davis, but you raised it in your reply brief.
Okay.
Okay. When I read your main brief, what I took your main brief to be saying is that they didn't exhaust their administrative remedies, and whether somebody has failed, whether an argument that somebody has failed to exhaust their administrative remedies really goes to, I think, is waivable.
Yes, on the administrative, yes. And,
but that's your main brief.
But when the waiver issue was raised in the opposition brief, in our reply, we addressed the Davis holding and the Central Transport holding, which we believe take this case, this argument we're making out of the waivable character because the regulations establish an exclusive federal form, as almost every case that addressed it at the trial court level has found, with the exception of the Wisconsin case, Slazinski. There are two quick points I'd like to make. Let
me just say, the concern here, which I'm sure you already appreciate, you may be correct. And if it is truly subject matter jurisdiction, and we would have to look very closely at Davis, it can be raised at any time. But here we have been through an entire trial, right? And I mean, where was your client? I mean, I'm not asking you, but in other words, it's so obvious. It's so obvious that there has to be an administrative challenge if somebody is relying on, first of all, you were relying presumably on the fact that your employee had not obtained the necessary DOT certification. And then if he was relying on somebody else's certification, I presume you looked at that and said, well, that was based on incorrect information. I mean, why was that not raised, right off the bat?
Your Honor, I can't explain or speculate. What I would say to that, though, is that I believe that the burden was shared equally because the plaintiff, as the DOT-regulated driver and represented by counsel, had every opportunity to also know that he had an appeal process through the DOT administration to follow, where the central issue here, the dispute here, went solely as to his qualifications, to his medical qualifications.
If we conclude that it is not subject matter in the purest sense, subject matter jurisdiction, I mean, there's the cases that you cite in your main brief, got to go through the DOT, got to go through the DOT. Let's assume that we conclude that it's not subject matter jurisdiction. What do we do with it?
Well, I would suggest then that on the other issues in the case, which is that there's a failure of evidence to support the claim that he was regarded as having a substantial limitation of the major life activity of working, our contention is the only evidence at trial was that he was certainly regarded as not having a validly issued DOT medical license.
So it's JNOV?
Excuse me?
It's
yes.
JNOV.
And so that the verdict should be overturned, the case dismissed for failure of proof on because this was simply a regarded as case.
But what about the fact that he doesn't make out a prima facie case because he doesn't have the required DOT certification?
Well, he had a DOT certification.
But it was invalid.
Well,
but he didn't have it for this company. When he applied for this company to drive, he didn't have a valid DOT certification. It doesn't matter that he got it afterwards.
There's no evidence in the record that he ever had one afterwards.
But he didn't have it when he applied too, so then he would, can't you then say that he wouldn't have a valid he wouldn't have a DOT certification, and he has to lose on that ground.
I don't know the answer to this, but could your company, I know they didn't, but could your client accept Yellow Transport or those other two companies
License. Yeah, that was my question as well. He goes to work for a new company. Does he have to go through a new medical examination?
Two parts of that answer. One, the cases say that my company is certainly not obligated to accept the credentials issued by a competitor. But more importantly, there are two cases, the Murphy versus UPS and the Chandler case. Both those cases, the carrier, the employer, had reason to believe that the license issued to the driver was obtained fraudulently. And in both those cases, they quote the same language. The language is, "Woe unto the employer who puts such an employee behind the wheel of a vehicle that becomes involved in an accident." That's exactly the scenario that was faced with by my client in 1999. They had four doctors, two different doctors tell them 4 times this guy does not meet the requirements. Yeah. They had 2 arbitration proceedings, which they won both of. He comes in January 1999 with all these other licenses, and Mr. Everett admits and tells them, "I lied. I didn't tell these doctors that I had a mental illness, that I had a 2-week psychiatric hospitalization."
So, in answer to the Chief Justice's question, if we decide, contrary to you, that the Superior Court had jurisdiction to hear the case, then we could also rule for you because the plaintiff wasn't certified at the time
he did not meet his prima facie case of showing that he was qualified, or that we regarded him as being anything other than not having a valid DOT license. If he could drive a truck, he just couldn't drive a regulated 10,000-plus pound truck.
And was that raised below?
Yes, well, it was raised in the sense that my client, Mr. Drew, testified on a number of occasions that...
But there was no objection to the jury instructions, is that right?
There were no objections to the specific jury instructions. But that goes, Your Honor, to the... I would submit that goes to the exact issue on the preemption situation, because here...
I understand, but again, it's very circular, because if it's subject matter jurisdiction, that's fine. If not, there may well be waiver all through this case.
But
I don't know that.
But not on the regarded as. The plaintiff had the burden.
No, I understand that, but that's not a waivable issue. Then you're back into the prima facie case, and that was submitted to the jury without objection to the jury instructions.
And our argument is that the evidence was insufficient to support that verdict, that there was no evidence that he was qualified or that he was regarded.
There was a motion for JNOV?
There was a motion for JNOV.
Which was?
Denied.
Denied.
Yes,
okay.
Your Honor.
And that's been appealed?
Yes,
okay.
Your Honor.
Thank you, Mr. Feldman.
Thank you, Your Honor.
Mr. Foyer.
Thank you, Your Honor. Jeffrey Foyer, I'm here today with my co-counsel, Lee Goldstein. My client, Joseph Everett, is also here. As Your Honors have pointed out, there has been waiver throughout this case. Every issue that has been raised on appeal was waived below because there was no objection.
What about the failure to make a prima facie showing of DOT certification? Was that waived?
Yes, and actually there is evidence to support that. The DOT certifications that Mr. Everett submitted into evidence were admitted into evidence without objection by the other side. And that's...
But they came after, didn't they come after he was not rehired in 1997?
After he was, that's right.
And if
but
your claim is on the 1997 action...
Our claim is on the 1999 action, their failure to rehire him in 1999. At that point, he presented them with 5 valid, facially valid DOT certifications. Was part of the
evidence that they weren't obligated to accept those?
No, there was no evidence as to whether they were or were not obligated to accept them. However, the way the DOT certifications work, and remember, this is a case not about DOT certification, but about discrimination as to whether or not they regarded him as being disabled. He presented them with valid DOT medical certifications. Those are necessary to be able to drive. He also had a valid...
Excuse me, I thought he admitted at the trial that they weren't valid.
No, he did not admit they weren't valid. He admitted that he did not tell the doctors that he had had a hospitalization.
Well, wouldn't that affect the doctor's decision?
It might affect the doctor's decision. It also might be the doctors were required to do an independent examination. In fact, the defendant's doctor, Dr. Roston, when he examined him, Mr. Everett had also put down that he had not had a prior hospitalization. And at page 1008 of the appendix, Mr. Everett testifies that Dr. Roston changed the medical history after talking to my client.
But
we have no idea what happened with the other 5 doctors who examined him.
I take it he at least had the requisite paperwork.
He had the requisite paper, every piece of paper.
Validly issued and would have allowed him to operate one of these vehicles on the interstate highway system.
Absolutely. And he had been doing so, in fact, for 2 years between 97 and 99. He had been driving. He had a valid CDL license, which is a commercial driver's license, which is not issued by the DOT. The DOT medical certifications, also not issued by the DOT. Those are issued by individual doctors.
Well, that's what I'm trying to find out. Does a doctor give the individual the DOT license?
No. The doctor gives a medical certification. The doctor does a physical examination based upon the DOT standards that are listed in the regulations.
That's all he needs. That's the CDL license, and he needs, as I read 49 CFR 391.41, he needs
the
on
medical
his
certification.
person a photographic copy of that medical examiner.
Correct.
And that's it.
So this talk about a DOT license, there's no such thing?
No, there is.
No, there's a CDL license. That's a
Well, that's what I'm saying.
driver's
There's
license.
no such thing as a DOT license.
No, there's a DOT medical certification, but that's
There's
not
a doctor's
issued by.
certification.
That's correct.
Okay, so
Are the doctors somehow certified by DOT to issue these?
No. These are
Any doctor?
Any doctor can do this as long as they follow the regulations under 391.41. There are doctors who specialize in this. The other point is that when he went in 99 back to Translease and said to them, look, here's my DOT certifications, here's my CDL's license, this triggers an obligation under our discrimination laws to do an individualized inquiry at that point as to whether or not he is qualified to drive. They did 2 things. They, 1, refused to accept his CDL, his DOT certifications from other doctors, even though they were valid.
They're entitled to do that, aren't they?
They're entitled to do that, but they also, and this is again, if you look at the testimony of their president, they refused to send him back to their doctor.
Is one way of looking at this case to say that lurking in the background is the possibility of at least subject matter jurisdiction as to one of the issues that has to be determined? But that question of subject matter jurisdiction, whether he was properly licensed, doesn't even get raised or doesn't come into play unless the employer in this case contends that he does not have a valid license.
Well, it's not subject matter jurisdiction. That would be a matter of exhaustion of administrative remedies.
Well, what do you say about Central Transport and Davis?
The answer to that is the Supreme Court case in English versus GE and this Court's case in Tusty versus IAC. In English versus GE, this is a case of a worker at a nuclear power plant who allegedly was fired for a safety violation. There is the Nuclear Regulatory Commission, this is in my SIR reply brief, and the reason that this is brought up in the SIR reply brief is because it was not till the defendant's reply brief that we knew that preemption was going to be the issue, not exhaustion or primary jurisdiction. But in that case, the Nuclear Regulatory Act has a comprehensive scheme, and the Supreme Court of the United States has ruled that it preempts the state field of regulating nuclear power plants for the same reasons that they raise here, safety issues. In English versus GE, the Supreme Court says it doesn't supplant all state law claims. And she was when she was fired, she was allowed to bring a state law claim for intentional infliction of emotional distress. And the reason, even though there was this comprehensive scheme, which included, by the way, a scheme whereby if you were disciplined for reporting safety violations, you could have a hearing before the Secretary of Labor, and if you won, if the employee won, the Secretary of Labor had explicit statutory authority to order reinstatement, back pay, attorney's fees.
That strikes me as very different. There's no claim here that if he were bringing a case saying he was discriminated based on the fact that he was on the basis of his ethnic origin or his religion or something. I mean, that's not the issue here. The question is he was discriminated against because he was deemed to be unqualified under the DOT regulations.
Correct.
Well, that goes right to the heart of the regulatory scheme, doesn't it?
No, because the DOT, all it can do, and this is why I said it's a collateral matter, a subsidiary matter, all the DOT can do is determine, is he qualified to drive or is he not qualified to drive? Once they make that determination, there is no authority for them to order the company to hire him, to take him back, to give him back paid or make him whole or anything. All the DOT can say is he's qualified or not qualified to drive. If they say he's qualified to drive, he has to bring a discrimination claim if he claims that the company still regards him as being disabled.
But that's a sequence that hasn't happened here.
That's correct.
The point is, in real time, if the company says, no, we're not taking you back, we have real questions about the validity of your license, then the remedy is right to DOT under the regulations.
Couldn't your client have gone along that appeal procedure?
My client could have gone and the company could have gone.
Right.
Either one of them could. The regulations say either one of them could have done that.
I appreciate that fact, but they're saying we don't think he's qualified. He wants the job. Couldn't rather than bringing a suit at that time, shouldn't he have gone?
He could have, and perhaps he should have. I was not his attorney at that point, but that would be primary jurisdiction. That's where there's no case pending in the state court yet. The DOT would make that determination, and then he brings that lawsuit. That wasn't raised below.
Mr. Foyer?
That's why it is. That's why it is waived. It's not subject matter jurisdiction. It's a matter of exhaustion of administrative remedies. And yes, maybe he should have done that. There's no requirement that he do that. There is nothing in the DOT regulations that say it is mandatory.
Could you answer a couple of questions for me?
Certainly.
And see if you can just answer them factually and not whether or not they were waived or raised. In 1999, when your client sought to be rehired, he arrives and he presents a valid license to operate.
Correct.
It's valid on its face.
Correct.
In what was introduced in evidence as to what occurred at that point. That is to say, what explanation did the employer give to him?
For not taking him back?
Correct.
Okay. If you look at the testimony of Stephen Drew, the president of the company, and you look at pages 1645 through 1655 of the appendix, you'll see what the testimony was. But the basic testimony was that we don't think he's qualified. But more importantly than that, the company stipulated to this in pretrial. The stipulation in the pretrial memo is the following. Since at least the time of his discharge from Bournewood Hospital in 96, the defendants have believed and continue to believe that Mr. Everett is not physically qualified to drive a commercial motor vehicle because they believe he has a mental disease or psychiatric disorder.
But that's exactly a disqualifying factor.
No, it is not. He has to have a current mental disease or disorder, not a history of one. If you look at the DOT regs under the qualifications, it's very clear that some conditions are disqualified if you have a history of them.
Okay,
the discrimination case requires them to make an individualized determination at the time.
It was done in 1997.
Which would be in 97. Then he comes
back.
It
said that the nature of the mental disorder was a continuing lifelong disorder.
No, there is nothing in any of the reports that say that.
Oh, I thought there was.
No, there is not. There is, in fact, Dr. Lubit, who is the IME, says he doesn't have any symptoms right now. His symptoms might return.
Excuse me, one of the doctors said that there was a reasonable degree of medical certainty that his condition was a lifelong illness, paranoid schizophrenia.
That's correct.
Okay, so then there is what Justice Cordy just said.
I'm confused.
Well, there's a second part to that. You can have a mental disease, and if you look even at the MCAD's amicus brief, they reference this. In the DOT regulations, having schizophrenia does not disqualify you.
Mr. Foyer, could you...
What disqualifies you is that you have symptoms that interfere with the ability to drive a commercial motor vehicle safely.
Mr. Foyer, can I ask you another question?
Yes.
You having told me what the President testified to and what the stipulation was. The next question is the following. Is there anywhere in the evidence from any source, stipulation or either side testifying, that your client, in obtaining the license post-1997, I don't know when he obtained whatever, whether it was one or more licenses to drive for other transport companies, whether he did not disclose to the examining physician a prior history of mental illness?
Yes, there is evidence of that.
And by whom and what was the nature of that evidence?
The evidence was my client testifying. He was asked whether or not he put that down on the forms. There was one
Was this on direct examination?
On cross-examination.
Okay.
In the trial or the grievance proceeding?
In
the
trial.
trial. I asked about the trial.
In the trial. And he said he did not disclose that. And the reason he didn't disclose that was because he does not believe and did not believe that he had any mental illness, that he was misdiagnosed.
Okay. So
in his mind, he was answering the form correctly.
truthfully. And was he cross-examined on that point?
Yes, he was.
And what was the nature of the cross-examination?
Just that solely that you lied on these forms, didn't you?
And he disavowed that. He said,
he said he disagreed with it being a lie. He did admit that it was that he did not tell the truth about prior hospitalizations. That he said, no, I didn't have any. But not all of the forms, not all of the health forms asked whether he had a prior hospitalization. Some of them asked whether he had a psychiatric disorder or a mental disease. So not all of them asked about hospitalizations.
So I take it from this, and you said that there were a number of certificates, you call them DOT certificates, were submitted in evidence without objection. And
yes.
I take it that there was examination about what were the forms that led to those certificates being issued also introduced in evidence?
Some of them were, not all of them, no.
Okay.
And there was no testimony at all of any kind from any of the doctors who issued those certificates as to what examination they conducted of him, what questions they asked of him, how thoroughly they examined him, or anything else. The company's doctor, Ralston, who issues DOT certificates, said in his testimony that he's very used to truck drivers coming in and lying to him, and that he conducts a thorough examination of them to make sure that he's made an independent determination of whether or not they, in fact, are qualified under the DOT standards.
Counsel, I have a fact question.
Can I just follow up one more, Justice Cordy? Did Dr. Ralston testify anything along the following lines, that in his view or opinion, had that information been disclosed to any, in other words, the hospitalization, let's say, not the name, the hospitalization, that information was material to a doctor complying with the DOT regulations?
I don't believe he said that specifically.
Okay.
But he did say that my client testified that he had put down no when he had been interviewed by Dr. Ralston, that he had had no hospitalizations, and that after Dr. Ralston interviewed him, or examined him, I should say, Dr. Ralston changed the form because he got the correct answers from him.
Thank you.
One
Justice Cordy?
fact question and then a quick law question. Fact question. The issue of the forms that were filled out not being full and complete, did that come out in the grievance proceeding first? Did it come out even before the grievance proceeding? When did this come out? When was the employer aware of this?
Well, there's no evidence in the record about what happened exactly at the grievance proceedings or what happened at the MCAD. But this was not this 1999 event was not a surprise to the defendants because there was an MCAD hearing concerning.
But that was long before.
That was long before this.
It had nothing to do with.
And that information was in front of the MCAD, and it was in front of. It was part of the grievance hearing.
Excuse me. The information.
The information
that he had not
of
filled,
the hospitalization. Of the hospitalization.
Yes, because the health forms. The health forms were part of the grievance proceeding. The health forms that he had filled out.
I'm sorry. Now I'm even more confused. The MCAD proceeding related to the 1996 refusal to rehire, or whatever it's properly called. 1997 or 1996?
1997, but there was also a further MCAD hearing, and this is not in the record.
All right, I'm way off. Okay, further MCAD hearing?
Yes. There was a lack of probable cause found in December of 98.
Yes.
In January of 99, my client filed his second grievance to go back to work.
Yes.
In February of 99, a month after that, there was an MCAD preliminary hearing on the lack of probable cause. It was an appeal of that. And I submitted that, all of the stuff that was submitted in the January 99 grievance hearing was submitted to the MCAD at that point.
They had closed their investigation at that point.
Well, not according to the investigating commissioner. If you look at his letter, which is at A232, the appendix 232, he says he finally dismisses the case in May of 99 based upon information provided at the February 1999 hearing and evidence adduced in the investigation. He says both of those. He took evidence at the 99 hearing, and he says so in his dismissal of my client's claim.
All right. Second question, just the law question side of this. You have said throughout, and I vaguely understand it, don't really understand it, that this is a question about perception. The issue in here is that this person was perceived as disabled, and therefore he was discriminated against. Given whatever that means in this context, is it your position that you didn't have to establish that he was qualified? Or do you still have to establish that he was qualified in order to make the case?
Still have to establish that he was qualified.
Thank you.
I just have one question. How do you rebut the position taken by MCAD that the 1997 complaint does not encompass the 1999 issue?
Well, the 97 complaint does say, the charge in 97 talks about a continuing refusal to return him to work. And as I said, if you look at the scope of investigation of the MCAD, they considered information that came up in 1999, specifically the information that was given to the company at the grievance hearing in 1999.
So these other certificates, these other medical certificates?
They were all in front of the MCAD. Now, that's not in the record.
Mr. Foy, I know we're running over. Was that raised by the employer in this case?
Never.
Well, it cannot be raised by an amicus.
No. It was never the exhaustion before the MCAD was the first time it was raised in this case was raised at JNOV, which is why, since they didn't plead it and since they didn't raise it pre-trial, which is why there's no evidence at trial put in about whether or not there was proper exhaustion. How would we know to put in evidence when this was not a defense that was pleaded?
But Mr. Feldman says that at the start of the trial, not before, somebody stood up and said, we're waiving any claim based on 1997. We're only focusing on 1999. And that was not what the subject of your Superior Court complaint was.
Well, our Superior Court complaint says there's a continuing refusal to return him to work, that there were several times.
Then there was a stipulation that you were only referring to 1997, according to Mr. Feldman, that you only.
No, there was no stipulation to that effect.
99.
To 99.
Yes, we waived our claims prior to that.
For 97.
For 97.
For 97.
Right.
But the company knew about the 99 stuff because they had been participants in the MCAD hearing in 99. They had been participants in the grievance hearing in 1999.
But that didn't mean you were raising that at trial.
I'm sorry?
But that did not mean you were raising that at trial.
That's exactly what we raised at trial. We talked about from the beginning when we filed our complaint that there was a continuing refusal to return him to work. And even the case law here says that you can talk about a continuing refusal to do that, just as you can talk about a continuing pattern of racial or sexual harassment.
Mr. Foy, I hate to interrupt you, but your time is up. Thank you.
Thank you.